Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 263. The name of the case is Principal Commissioner of Income Tax versus TRIMEX FISCAL. This case has been reported in 449 ITR at page number 407 and the date of the judgment is 25th August 2022. This case relates to the assessment year 2013-14 and in this case the proceedings under section 263 for revision was initiated by Commissioner against the assessee for the order passed in which the issue relating to section 56 subsection 2 clause 7b, which says about the issue of shares at premium, or you can say that in that section if the shares are issued above the book value, then the value which exceeds the book value is treated as income of the assessee under income from other sources. 263 says that if the order passed by the assessing officer is erroneous and prejudicial to the interest to the revenue, then it is erroneous. And if it is prejudicial to the interest also, then revision can be done. Now the question arises that when an order is erroneous, in the journal parlance, it is seen that when the assessing officer does not make the inquiry and passes the order, then it can be said that the order is erroneous. Whatever the step should be taken by the assessing officer, that steps has not been taken by the assessing officer, so the order is erroneous. As far as this much law is concerned, it is okay. But in this particular case, the assessing officer made all the inquiries about the issue of shares at a premium. The assessee participated in that query. All the documents, valuation report, etc. were filed and the assessment order was passed. It was the viewpoint of the Commissioner of Income Tax that section 56 subsection 2 clause 7b says that the satisfaction of the assessing officer should be there. So the court deliberated on this word satisfaction, that satisfaction should be vivid. The satisfaction should be very clear and it should be recorded by the assessing officer while passing the assessment order. Meaning thereby that if the assessing officer made the inquiries, the due deliberation were there and even the assessee has submitted the documents, then it is not sufficient. The assessing officer should deliberate into the assessment order itself that the issue has been discussed with the assessee and the assessing officer has taken this viewpoint. And the Calcutta High Court said that since the assessing officer has not recorded the satisfaction in the assessment order, the order is erroneous. My viewpoint as an author is that with very due respect to the Calcutta High Court, whether it is possible for an assessee to say the learned assessing officer that while you are passing the assessment order, then please record your satisfaction on each point on which notice under section 142 subsection 1 has been issued to me. Suppose if in scrutiny notice ask about 30 queries from the assessee and assessee gives reply for all the queries, and if the assessing officer does not record the satisfaction in regard to all those points, then it means that on whatever the point the satisfaction has not been recorded into the assessment order, on that point it will be erroneous. Although section 56 subsection 2 clause 7b specifically says that there should be satisfaction. But as we know that satisfaction word is very common in the Income Tax Act. So the department will use this case law in a very erratic way, because it is not possible in any manner that on whatever points the assessee has given its submissions, that on every point the assessing officer will be able to record the satisfaction in the assessment order. We all know that how the assessment orders are passed. So if the assessing officer does not record the satisfaction, then how the assessee can be penalized for that, for initiating the proceedings under section 263, because it is not in the hands of the assessee to say to the assessing officer that please record the satisfaction and please deliberate on each and every point into the assessment order. So, according to my viewpoint, this order is going to be very severe repercussion as far as section 263 proceedings are concerned. So, in this case, the Calcutta High Court upheld that whatever the proceedings under section 263 has been initiated by the Commissioner of Income Tax are valid because the order is erroneous for want of non-recording of satisfaction in the assessment order by the learned assessing officer. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus TRIMEX FISCAL, and this case has been reported in 449 ITR at page number 407. The case has been decided on 25th August 2022. Thank you, friends.